When I do introduce myself at dinner parties, I sometimes get a very odd look from people when I say that I'm a business and human rights expert, and the business people look at me a bit strangely and human rights activists look at me a bit strangely, but the two actually do increasingly go together these days. And I've just popped up a slide which is by no means complete, and if you just to show you three things really. The first is to show you, I guess, the number of companies at the moment in different sectors that have been facing human rights related allegations or claims, whether they're phrased in human rights terms or phrased differently, particularly in the last 10 years. So you can see quite a variety of sectors up there. A lot of extractive companies with big physical footprints, as you'd expect, but also companies like Vodafone, like Google, like Apple, that are facing human rights related allegations. Vodafone recently, in relation to the Arab Spring, when the mobile phone network was used in connection with the Egyptian government to basically turn off people's phones, send text messages from the government, other issues relating to freedom of expression and privacy. So Vodafone faced allegations using very, very strong human rights terms in relation to that situation there. Apple, I'm sure nobody is unaware of what has been going on in terms of Apple's supply chain in China and some of the labour issues related to their supply chain. ANZ is up there because of facing allegations relating to some of their project finance and loans to parties in Southeast Asia and some of the implications of those loans. So even a bank that's one step, I suppose, removed from some of these direct activities has started to face human rights related claims. Telstra is up there related to some of the access issues in Indigenous areas, but also because it was actually the only company to make a submission to the federal government when we were talking about whether we should have a federal human rights charter. So Telstra taking a stand in terms of actually coming out in favour of having a national human rights charter. And then quite a few, as I said, kind of mining and oil and gas companies up there in relation to allegations relating to land issues, resettlement, cultural heritage. Barrick is up there in relation to some issues in Tanzania and Papua New Guinea in terms of the use of their security providers. So using security companies, private security providers who used excessive force, were implicated in rape and other issues of gender violence, and then those issues being linked back to Barrick, and Barrick taking some very, very serious steps to address how they deal with private and public security providers. So this, I guess, shows that that it's happening all over the world in terms of these types of issues, the types of sectors and also the types of rights that I'm talking about. So in terms of human rights, the entire spectrum of internationally recognised human rights that are starting to pop up in relation to companies. I will go on in a moment to talk about the UN process and the guidance that we now have in the UN system. But there is a recognition now from all of that work that there's a responsibility to respect human rights by business, which essentially is a do no harm standard, don't do bad things, in relation, as I said, to all internationally recognised human rights. The business case for this is actually very clear. So this is not something that is seen by the companies whose logos I just had up on the board as a nice to have. It's actually seen as core to business success. And the reason is that if human rights are not respected, that all sorts of negative consequences can flow. So anything from legal claims, which we'll talk about a little bit more later, to loss of public advantages such as export credits, to operational delays. If a mine is shut down for 2 weeks because of a community protest relating to cultural heritage or other land issues, obviously it's going to mean significant impacts for the company. Divestment. So we've seen pension funds, particularly from the Northern European states, in some cases divesting from companies because of their human rights record. In the past, it would have been very much linked to environmental damage. Now we're seeing human rights becoming part of, I suppose, the ethical principles that some of these socially responsible investment funds are taking up. Conversely, obviously, the upside can be, opportunities that are gained because you're seen as a company that acts responsibly, employee satisfaction, again, investor interest. So the positive, impacts as well as negative impacts of doing things badly are really starting to come through in the international realm. So to help navigate this very, very complex area, Professor John Ruggie was appointed in 2005, as we heard before, to really take this space forward and provide guidance to all of the stakeholders operating in this space. But before we talk about that, it is a good idea just to think about the background to this area, because it was quite a complex world that John Ruggie entered into in 2005. In 2003, there was a document called the Draft Norms on Business and Human Rights that was put forward to the Subcommission on Human Rights, which was then the advisory body to the Commission on Human Rights, the UN's main human rights body at the time. The Draft Norms on Business and Human Rights were basically a document that purported to place onto companies the same types of international human rights legal obligations that governments have. So it was the duty to respect, protect and fulfil human rights, not the entire spectrum of internationally recognised human rights, but the entire spectrum of state duty. So it really was to respect, to protect, to fulfil, to promote. And as I said, the implication was that these duties would actually be imposed on companies under international human rights law. You can imagine that companies were not particularly thrilled with this document that would place international legal obligations onto them. Governments were also not very fond of the document because it was seen as conflating state and company responsibility. Civil society was generally in favour of the document because it had a lot of valuable elements to it that at the very least did help to increase corporate accountability for human rights harms that were going on. So the Commission on Human Rights, upon receiving this document from the Subcommission, its advisory body, did something quite unusual. It actually declined to adopt the draft norms. Ordinarily, when something was sent from the Subcommission to the Commission, they would have accepted it. But the Commission actually said, thank you, but no thank you. We recognise that this document has helpful elements, but it has no legal standing, and we're sending it back to you for reconsideration. We're not taking this on. The UN then spent a year looking at business and human rights and thinking about how to proceed. And in 2005, it was decided that that a new special representative on business and human rights be appointed to really lay the ground again, to start again, to look at what this space was doing. Professor John Ruggie was appointed to the position. It technically is part of the special procedures of what is now the Human Rights Council, so the Commission on Human Rights became the Council, which many of you would know. And special representatives are different to special rapporteurs, which are also special procedures, in that they report directly to the Secretary-General as well as the Human Rights Council. So Professor John Ruggie was appointed to this position. He has quite a significant background in international affairs. He's a Harvard Professor of Global Governance, but also had been Under Secretary-General to Kofi Annan in around 2000 and helped to draft the Millennium Development Goals and to set up the UN Global Compact, which is the world's largest voluntary CSR initiative. So Professor Ruggie was appointed to this position, and I joined him in 2006, so I joined him just after he started this. But describes coming into just rooms filled with tension, basically. You could cut the tension with a knife, where people from different stakeholder groups, whether it was civil society, business, government, investors, would not even really want to sit on the same side of the table as each other because the debate had become so divisive after the draft norms. So his mandate was really to assess what governments were doing in this space, what companies were doing in this space, to look at concepts like human rights impact assessments, complicity by companies, to look at best practice. And he decided very, very early on that the only way that he was going to be able to move forward was to do a lot of mapping, do a lot of, increased understanding about where the scene was at, but also not to take on the draft norms, because the draft norms had become such a divisive document in this space, and he also didn't agree with a number of the contentions in it. So he was appointed in 2005 and set about straight away going through a very consultative process getting a lot of people around the table. Over 6 years, I was with him for 5 of those, we had over 60 consultations around the world. And I can tell you that from the progression, at least that when I was there from 2006 to 2011, there was a real change in how people started to approach the issue and approach each other, which was very good to see. So in June 2008, which was the end of his first mandate, his first 3-year mandate, Professor Ruggie decided to go with one recommendation to the Human Rights Council, which was quite unusual. Often you would see special rapporteurs or representatives putting forward a number of recommendations. He decided to put forward just one, and that is that there should be a new policy and conceptual framework for dealing with business and human rights, which I'll go through in a moment. It's called the Protect, Respect and Remedy Framework. Basically, what we had seen in the last couple of years between 2005 and 2008 was that there was a lack of common language, common understanding about how to even deal with business and human rights, who were the key players, what language to use. So he chose to create this framework and asked the UN Human Rights Council to endorse the framework and to help him move forward with that. The UN Human Rights Council unanimously welcomed the framework, which was a very, very significant step if you think back to 2004 when the Commission refused to accept the draft norm. So that was for the UN kind of heads in this room, that was actually a very significant event. For his sins, Professor Ruggie was given another 3 years. So usually mandate holders have 6-year terms, and he was given another 3 years to go off and operationalise the UN framework on business and human rights. That was the phrase in the resolution, to operationalise. Again, went through a very consultative process and came up with the UN guiding principles on business and human rights, which I'll go into later. And submitted them to the UN Human Rights Council. A year ago, they were unanimously endorsed by the Council. Again, for the UN heads in the room, the word endorsed was actually used. We endorsed. That was a very, very significant word. Sounds like an episode of The Hollow Men, but it was actually a very important word to be used in terms of something that the Council had not drafted themselves. So we were all probably far too excited that they'd used that word, but it was exciting at the time. And that was the end of Professor Ruggie's term, so that was the end of his mandate. And the UN Human Rights Council decided to appoint a 5-person working group in his place. So we often tease him as well that he needed 5 people to replace him. So the working group has been set up. It had held its first formal session. And I'll talk about the mandate later, but we are very lucky to have one of the mandate holders living in Australia, in Adelaide. She's actually Colombian and was appointed by the South American group, but is based in Australia. Okay, this is the Protect, Respect and Remedy framework. It has 3 pillars. It's the state duty to protect against abuses, human rights abuses by third parties, including business, through appropriate policies, regulation and adjudication, and I'll go into that in a moment. The corporate responsibility to respect human rights, which in essence, as I said before, is a do no harm standard, that companies should act with human rights due diligence to know and show that they're respecting human rights, and greater access by victims to effective remedy, judicial and non-judicial. And that's just a recognition that even with the most beautifully drafted laws and company policies, that things go wrong, bad things happen, and there does need to be access to remedy for victims of corporate-related human rights harm. I'm just going to spend a little bit of time going through each pillar of the framework and what the guiding principles do say about each pillar. The framework was really the what, so it was a framework of shared responsibility. What are the responsibilities that government, that companies have in this space? What are the key elements of remedy? The guiding principles really set about to show the how. So how can governments actually act in this space to protect human rights in terms of company-related human rights abuse? How can companies act in this space? As I'll turn to later, despite that, it wasn't meant to be kind of an off-the-shelf handbook that you just plug in. Obviously, many states around the world and thousands of companies have to translate this for themselves, but it was meant to be more of a guidance than the framework allowed. So the state duty to protect against business-related human rights abuse provided guidance in terms of what governments can do within their own territory and jurisdiction, as well as what they might do in terms of extraterritorially if they have a company that's incorporated within their jurisdiction that is acting irresponsibly abroad. It talked about state regulatory and policy functions. So it talked about the importance of having laws in place such as non-discrimination laws, privacy laws, that can actually provide guidance as well as encourage and require companies to behave responsibly. We did quite a bit on corporate law, so we looked at directors' duties, at disclosure, at incorporation and listing, at some of the issues that perhaps might encourage or discourage companies, as the case may be, to act responsibly and respect human rights. We looked at the state-business nexus, so we looked at those types of relationships where the state is particularly close to a company and therefore might have, from a policy point of view, as well as in some cases from a legal point of view, I guess more of an ability to act and to encourage and in some cases require human rights respecting behaviour. So export credit agencies, when states enter into investment agreements with companies, procurement, those types of situations where the government is actually either state-owned enterprises, of course, so where the government is actually very, very close to the company or perhaps supporting it in some way. The guiding principles look at supporting the business respect for human rights in conflict-affected areas. So those areas where the human rights regime cannot possibly be expected to function, what could the host government, if it exists, do in that space? But more importantly, what again could a home government do to actually encourage and again require companies to respect the human rights of people in conflict zones? We were just having a chat before about parts of the Australian Criminal Code, Commonwealth Criminal Code, which actually make it possible for a company to be held liable for complicity in an international crime abroad. And the mental element there, the element that is part of proving whether the company could actually be held liable, is that the company has a corporate culture that has allowed complicity in an international crime to occur, so genocide, crimes against humanity, war crimes. That provision in our criminal code is actually one of the, that does not exist in many criminal codes around the world. So provisions like that can actually have, potentially have an impact. That being said, that particular provision that I'm speaking about has never been used. There was an investigation into anvil mining by the Australian Federal Police, but it did not go any further. But the provision, has the capacity to be used. Ensuring policy coherence. So we talked about vertical and horizontal policy coherence. So vertical coherence in terms of governments actually being aware of the human rights obligations that they've signed on to. Horizontal policy coherence in terms of departments like the Department of Foreign Affairs and Trade actually being lined up with Treasury or resources or other departments that are working with companies, so that they're aware that there might be issues there in terms of Australia's or other countries' human rights obligations and how they're dealing with companies. And we looked at quite a few interesting initiatives there, such as where some governments, the UK government in particular, has now given guidance to all of its diplomatic missions abroad to explain what support might be available to a company that comes to that embassy and says, I want to invest in this country, I'm aware of the potential human rights risks, can you please help us? So all of those types of issues came up under the state duty to protect. The corporate responsibility to respect, which is the second pillar of the framework, very deliberately called a responsibility, not a duty. And that was because what we found was, unlike what the norms had said, that there was generally no direct international human rights legal obligations on companies. There are some exceptions, but that generally those obligations didn't exist. That didn't mean, however, that companies themselves and others were not holding companies to account either under national law or under more, I guess, the court of public opinion, so in terms of social license to operate. And we found that many companies themselves were acknowledging that they had a responsibility to respect human rights. Very deliberately used the word respect. So as I said before, in human rights terms, respect essentially means to do no harm. It doesn't mean it's a purely negative duty. Obviously, sometimes to respect human rights, to actually do no harm, you have to engage in positive acts. But it was the baseline expectation that we set. Companies obviously can choose to fulfill human rights by building hospitals and schools and all sorts of other activities that might be part of philanthropy or social investment. But we were talking about the responsibility, to respect human rights, to do no harm. And I should say, in the very beginning, we'd come across many companies and asked them to speak at some of our meetings. and get a very nice presentation on philanthropy, which we'd say thank you very much for, but we'd like to know how you're actually avoiding doing harm in your own operations. So it was quite a shift sometimes to speak to companies about this. The key elements of the responsibility to respect human rights, so how does a company really know and show that they're respecting human rights, is to have, first of all, a policy commitment that's been approved at the highest levels of the company that acknowledges the company's commitment to human rights. It doesn't have to be called a human rights policy, although a lot of Australian companies now have a human rights policy, but some form of commitment that shows the company's employees, other stakeholders, investors, that the company is actually committed to respecting human rights. Human rights due diligence, which basically borrows from transactional due diligence, but it's ongoing, to say that companies need to, again, put in place certain processes so that they know and show that they're respecting human rights, so they understand their human rights impacts, they're tracking their human rights performance, they're communicating to people where necessary, basically knowing who you're operating with as well. So all of this applies not just to your own activities as a company, but to any involvement that you might have in a human rights related harm, so including through your business partners. So human rights due diligence, one of the key differences, I suppose, if we've got any corporate folk in the room, to ordinary risk management that a company might do, is that human rights due diligence focuses not only on the risks to the company itself, but on the risks of rights holders. So it's not okay to, I suppose, balance something out and say, well, something could happen, but it's not particularly going to harm the company. The company needs to understand what the impacts might be on itself, but also what impacts it might have on rights holders and how to go about preventing and addressing those. Remediation. So the guiding principles talk about the steps that a company should take, particularly where it's caused or contributed to harm, to help address human rights related abuse. It may not be the company itself taking action, it may be being supportive of a judicial process, but just some of the steps that companies can take. And issues of context, which sounds a little bit vague, but basically in the guiding principles, some of those tricky issues are discussed, such as what do you do when you're operating in a country where the national laws not only don't come up to the level of international standards, but they actually conflict with international standards, and what do you do in those types of situations? No easy answers really provided in that space, but suggestions that companies do at the very least try to live up to international standards, work with peers, and see about how they can live up to the spirit of international standards. I should have said that we're talking about all companies, so it could technically be the fish and chip shop down the street, and it could be the largest mining company in the world. Obviously the way that a company is going to fulfill its responsibility to respect human rights, act with due diligence, will differ depending on the scale and the scope of its work. But you know, at a baseline level, the corporate responsibility to respect human rights is meant to apply to all companies. And it's all human rights, so all internationally recognised human rights, basically all of those in the Universal Declaration of Human Rights and the 2 international covenants on civil and political and economic, social and cultural rights. Access to remedy, which is the last pillar of the framework. So again, we looked here at a variety of different types of mechanisms. We looked at state-based judicial mechanisms. So obviously, what remedy is actually available through the courts in this space, whether in a host country or a home country, and what are the barriers to access to remedy that victims of corporate-related human rights abuse might find. Can I just get a show of hands of who has heard of the Alien Tort Claims Act? Oh, one? Okay. I'm going to explain it very, very simply because we don't have that much time. But the Alien Tort Claims Act is a piece of legislation that is very old, that exists in the United States, that was basically created to deal with piracy as well as diplomatic, to, I guess, help manage diplomatic relations in the United States to avoid some of the issues that might pop up if harm was occurring against diplomats in the US. That allows anybody, no matter where they're from, to bring a claim against anybody, no matter where they're from, against a breach of the law of nations, regardless of where it occurred. There just has to be quite a tenuous link between the defendant and the United States, but it could literally be an office or something like that. It doesn't have to be an extremely strong link there to have standing to bring a case in terms of this legislation. About 20 years ago, somebody very enterprising decided that they would use this piece of legislation to bring claims against companies for civil liability for complicity in international human rights abuses. So since then, we've seen quite an increase in the use of this piece of legislation in the US courts, with a lot of division over whether it should actually be used for this purpose, whether companies can actually be held liable under international human rights law because it links into whether that piece of legislation can be used, what types of human rights might be relevant in terms of acts being occurred, what are the elements of complicity in this space, how much does the company actually have to know, and there are Australian companies that have been brought, that the actions have been brought against them in US courts relating to this piece of legislation. It's now before the US Supreme Court. There's a case against Shell in relation to some of its activities in Nigeria, and the case is on appeal to the US Supreme Court, and there is a possibility that that this legislation will no longer be able to be used for this purpose. But at the moment, it's one of the only, I guess, truly extraterritorial judicial remedies available in a home court. So it's something that's quite important at the moment. State-based non-judicial grievance mechanisms. So we looked at things like national human rights institutions, like the Australian Human Rights Commission, which has a grievance mechanism for workplace discrimination. Some of those other mechanisms that are available at the state level, such as industry ombudsman. Australia has obviously a couple of industry ombudsmen. Also the national contact points under the OECD guidelines. The OECD guidelines are a set of guidelines that states sign up to that are not mandatory for companies, but if a government has signed up to the OECD guidelines on multinational enterprises, which now have a human rights chapter and provide guidance on how companies should behave responsibly, that government has to set up something called a national contact point, which is basically a form of alternative dispute resolution, a form of mediation, where somebody can bring a complaint about a company that has behaved contrary to the OECD guidelines. The Australian National Contact Point sits within Treasury, within the Foreign Investment Review section. It has not heard a lot of complaints under the OECD guidelines to date, but it is available, and other countries also have these national contact points. Non-state-based grievance mechanisms. So we looked at some of those grievance mechanisms that are part of the collective initiatives that companies sign up to, industry initiatives that might have mechanisms that you can actually go to. For all of these, and of course, I should say, apologies, operational level grievance mechanisms there. So the mechanisms that companies themselves set up to deal with complaints that come to them. And the idea there is that you're avoiding a complaint escalating without obviously barring any access to the courts, but you're really preventing something from escalating, and you've also got a feedback loop back to systemic issues, so that if something's popping up constantly in your grievance mechanism as a company, and many mining companies in particular have set up grievance mechanisms at the site level, that you will see what systemic human rights issues are popping up. The guiding principles include some effectiveness criteria for non-judicial grievance mechanisms. They're quite simple really. It's that the mechanism needs to be legitimate, it needs to be transparent, it needs to be rights compatible, it needs to be accessible to people. We did a pilot project with 5 companies to see how their mechanisms were really shaping up in terms of the effectiveness criteria, and found that one of the companies that had started to improve its practices actually found that there was a big spike in the amount of complaints that were coming to the mechanism. The company actually chose to see this as a good thing because they saw that it was more legitimate because it had changed some of the practices relating to the mechanism, whereas before they had changed some of those practices, nobody wanted to use the mechanism. And it was things like, for example, one of the companies, which I think was a mining company, had their grievance mechanisms office within the wall, behind the barbed wire of the site basically, so none of the community members were particularly interested in heading to the grievance mechanism, so things like that. The guiding principles have guidance on all of those issues that I've just discussed. They've become, in the past year, a real global reference point for providing guidance to governments, companies, civil society and others on how companies can prevent and address company-related human rights abuses. Even this time last year, I could not have imagined the momentum that has sprung up behind these guiding principles. Basically now, If you look at any of the key kind of corporate social responsibility initiatives, whether I've popped a few up there, whether it's the OECD or the International Standards Organisation, the EU, which I'll talk about in a moment, the World Bank, whenever they're talking about business and human rights now, they're using the UN Guiding Principles as their kind of key starting point. It's been quite an incredible development, and I'll go through what some of the other stakeholders are doing to implement them. They're not binding international law. As much as we like to give ourselves credit for making international law in Team Ruggie, we obviously did not make international law. They're guiding principles, they're not law. They are starting to be incorporated into national law, and who knows, one day we may see some form of treaty or agreement like the UN Convention Against Corruption that brings in some of these principles. But at this stage, obviously, it's not a treaty, it's not international law. As I said before, it's not an off-the-shelf handbook. We had a word limit of 10,700 words, so quite apart from that, which was a struggle, they're not meant to be, it's not something that you can just kind of take as a tick-the-box manual. Every company, every country has to decide for themselves how they're going to work with these. Just a few words about support and uptake quickly. Just some examples of what governments and others are doing. So states, as I said before, the UK has put together a manual for all of its diplomatic missions on how to work through issues with businesses on human rights. We've seen export credit agencies taking up the UN Guiding Principles and saying, when we now do due diligence on the companies that we're going to provide support to, we're going to look at the UN Guiding Principles to figure out how we should look at human rights issues. Writing national human rights action plans and human rights policies and those types of things. We've started to see all of that kind of pop into this. The EU last year put forward a new communication on corporate social responsibility, which asked all EU member states by the end of this year to put together implementation plans for the UN Guiding Principles. So they're basically, each EU member state is tasked with doing that. The UK in particular, as well as I believe Germany has started to do quite a bit of significant work on those implementation plans around the guiding principles. Business associations. So we did receive support from the International Chamber of Commerce, the International Organisation of Employers, a bunch of national business associations that are starting now to, again, as they're providing guidance to companies on human rights, to use the UN Guiding Principles as their terms of framing. Businesses, so starting to draft human rights policies, starting to look into their supply chains and think, who are we actually dealing with? Do we know who we're dealing with? Do we know what types of human rights abuses we might possibly be linked to? Looking at human rights impact assessments. So BHP has, decided to do a human rights impact assessment at every single one of its sites around the world. And as I said before, businesses starting to set up grievance mechanisms. Now obviously when we're talking about business here, there are a couple of leading companies, often those transnationals with the biggest exposure probably from a public point of view and who have faced the most scandals. But there's an issue here obviously that there are thousands of companies around the world, and we really have only probably reached a small number of those. There are a lot of laggards. But getting there in terms of business, and when you have businesses with very complex supply chains that are starting to put some of these obligations on their supply chains, the net kind of widens out. National human rights institutions, so not only Australia, which I'll talk about in a moment, but the Malaysian National Human Rights Institution, Suharkam, has been doing work on business and human rights. In the Philippines, in Kenya, have started to try and help build capacity in their own countries in terms of business and human rights by giving guidance to business in the educational space, but also to civil society to build capacity there to other groups. International institutions like the OECD that I mentioned before, civil society, using the guiding principles in terms of their advocacy techniques. One interesting development was that Oxfam Australia has actually decided to, in their mining work, move away from having a mining ombudsman, which is quite an adversarial kind of position that used to hear complaints against companies, to more of an engagement approach, where they still very much obviously campaign with companies and make companies, ensure that companies know when there are problems, but work in a more collaborative way with companies to try and help build capacity. And investors, the investor community, a little bit slower in Australia, but starting to take more of an interest in this space. The socially responsible investment community, but also those others who are starting to see that there is real risk here for a company that does not get this right and that can affect the share price. The new working group, which was created, as I said, to take over from John Ruggie, has been given a 3-year term. It's a 5-person working group, 5 independent representatives from the 5 geographical groups. The WEOG representative, so that's the Western European and Other group that Australia sits in. I'm always very upset that we are in the other. Is a lady called Margaret Junk, who is from the Danish Institute for Human Rights, which is Denmark's national human rights institution. But as I said, we do have somebody here who was appointed by the Colombian group, Alexandra Guaqueta, who is based at Flinders University. The basic mandate is to disseminate and implement the guiding principles. So to really make sure that the capacity grows widely around the world so that we get in more of those companies, more of those governments that haven't been as involved to date. Like Professor Ruggie's mandate, the working group is not a complaints handling mechanism, so it's really not there to hear complaints about companies. That being said, there's wording in the resolution from the UN last year that says that the working group can receive information, which was stronger than what John Ruggie had in his mandate. So it does mean that people can obviously impart information to the working group about what companies are doing, but they still don't have a complaints handling mechanism like other working groups might have at the UN. There is a specific reference in the resolution to a gender perspective and giving special attention to vulnerable groups like children, people with disabilities, migrant workers, Indigenous peoples or at-risk groups, which was good to see. And again, just building capacity there, so really trying to increase the take-up of all of these policies. That's the website for the working group if anybody's interested. They will also hold or help to hold an annual forum on business and human rights. That was in recognition of the consultative work that Professor Ruggie did in saying that at the very least once a year, business, government, investors, civil society, others should be getting together to discuss business and human rights. And the first annual forum on business and human rights will be on the 4th and 5th of December in Geneva this year. So if anybody's in the neighbourhood, not that it's a hop, skip and a jump away, that's what they'll be doing. Okay, key Australian developments. Just wanted to spend a little bit of time on this because we have seen quite a few developments in the past few years. I was living. Am I move along? Building up. Okay. Yeah. This is my last slide.
Couple of minutes.
Okay. So just quickly, when John Ruggie's mandate was created in 2005, there were 3 countries that voted against the resolution to create the mandate: South Africa, the United States, and Australia. South Africa voted against the mandate because they felt it didn't go far enough. They wanted Professor Ruggie to have a complaints handling mandate. The US voted against the mandate because of certain business pressures and also because of wanting to, streamline some of the international processes and not have more mandate holders. I'm not exactly sure why Australia voted no, but I have a feeling it's also because of reasons related to why the US voted in that way. Last year, when the guiding principles were unanimously endorsed, Australia co-sponsored the resolution on the day. They signed the document on the day. So that was a really good development to see that the Australian government had moved forward in that space. DFAT, Treasury, EFIC, which is our export credit agency, have all been doing outreach in terms of the guiding principles. DFAT now has a new group that really focuses on corporate social responsibility and is trying to help companies through this space, which has been good to see. The Global Compact Network Australia, which is the local network of the UN Global Compact here, has set up a human rights leadership group for business, which, shameless plug because I'm the person that coordinates it, but it's actually a safe space for businesses to come together to talk about human rights related issues that they might have in Australia and beyond. The Australian Corporate Accountability Network is a new NGO coalition that basically is working towards building capacity of NGOs in Australia to deal with Australian companies' human rights related issues, and then more focused by the Australian Human Rights Commission basically on business and human rights. This is just a link. The Business and Human Rights Resource Centre is the place that hosted John Ruggie's website, but it's also a place that does weekly updates on business and human rights, including by region. This is how I keep up to date with business and human rights development, so it's the best way of keeping up to date. And I've gone on for too long, so that's it. Thank you very much.
So, any questions? And if you identify yourself, if you... Yes, we...
Thank you very much, Vanessa. My name is Hashim Abdul Hamid from Monash Asia Institute. I'm very concerned about the fact that many of the international organizations, particularly business bodies, making business or doing business in the third world countries. A good example of it, a big disaster some 20 years ago, Bhopal in India. So many people were killed and nothing much has been done. And in Singapore, we've got Texas Instrument. In Malaysia, for instance, where I came from, the Japanese companies, and they are not worried about the human rights aspects of it, because they know the government is supporting them by saying, you come and perform your business here, we'll give you 3 years, 5 years, free, tax-free incentive, that sort of things. What can we do about this sort of problem from your perspectives? Thank you.
And it's a very good question. And so and I think the guiding principles, you know, those problems will continue to exist and they need to be worked through, but the guiding principles try and provide, I guess, a framework for governments, business and others who might be actually trying to lobby for those practices to improve. So one element is obviously if the company is based in a country that might be willing to, I suppose, encourage, or as we saw with some of the examples before, require more responsible behaviour overseas, that might be something. We're hoping that the UN guiding principles might encourage investors, lenders, you know, others to say it is not acceptable anymore to go into a country and behave not as you would in your own country, or to behave badly even if that is how you would behave in your own country. So we're hoping, I suppose, that the more scrutiny that comes from this, the more that those companies will have to behave better. Some of the situations, as I said before, in terms of supply chain, so that if the company itself does not really face that much pressure on the share market or through share price, but may face losing a major client or losing a major supplier because of their activities, that some of these things start to change. There have been calls for, you know, stronger national laws by home countries in this space, and as I said before, some kind of even international treaty that places obligations similar to corruption. But I think and as I said before, the Alien Tort Claims Act is a piece of legislation that's being used. So there's all these different kind of the web there, but I guess we're hoping that the UN guiding principles will be that first step to trying to improve it. But I mean, you know, those types of issues obviously are still occurring.
Thank you.
On the back.
Yeah.
Hi.
Hi, I'm Zane.
Can you speak up a bit?
Yeah, I'll come over here.
Come up a bit.
Sure. Yeah, my name's Zane, and I'm kind of not from anywhere, I'm just an individual. What would you say has the greatest effect on implementing sort of, you know, making businesses become more aware of human rights and making sure that they don't violate human rights? Would you say that it's more legislation or effects or things that may potentially affect their share prices?
Yeah. And I think it's, you know, all of these things often go hand in hand. We speak in the guiding principles about having kind of a smart mix of voluntary and mandatory measures so that it's not kind of one thing or the other. But I think some of the issues that I spoke about before, which is investor divestment, operational delays, reputational damage, employee dissatisfaction, that companies are taking extremely seriously. You know, these companies don't particularly want the words human rights allegation and their company name written in, you know, in big headlines somewhere. So I think it is increasingly those types of impacts, in addition to legislation, that's starting to affect them. And a lot of the companies that I see actually implementing human rights due diligence, they're not, if you ask them, are you doing this because of legislation, they'll say no, there's no one kind of making them do it, they just realise that they should be doing it. And I shouldn't say, I mean, obviously the business case is there, there are a lot of, you know, people within companies that are obviously doing this too because there's a moral, because it's the right thing to do. But the business case helps as well. Yes.
Helen, is it?
Yes, Helen Hill from Victoria University. I mean, this sort of takes me back to the early 70s when I was in New York once, and there was an organisation there called the Interfaith Centre on Corporate Responsibility, and they were really working out ways that civil society could leverage companies by going to annual meetings and things like that.
Yeah.
And then I was in Geneva when the Millennium Development Goals were being put to the NGO community, and Kofi Annan put up a big thing on corporate companies, and the civil society was hostile as anything to it because it was trying to get them, I think it was trying to get them to be involved in the Millennium Development Goals, but it looked as if it was really giving the companies the sort of equal status with countries, or certainly letting them off the hook for things like violation of human rights.
Yeah.
So I mean, it's good to see that this has come in. But one of the things, the other points made there, is that the UN system is full of different bodies of it saying different things. And you mentioned policy coherence, of which there seems to be not much sometimes among the different, you know, World Health Organizations fighting against global pharmaceutical company because the way they're ripping off people in the third world, and then other parts of the UN were propping them up and helping them. And I just wonder about policy coherence between this and the World Trade Organization, because there are some companies whose business it is almost to violate human rights, like logging companies, for example. I mean, where do they sort of fit in?
Yeah. And just for I'll answer that in a sec, but the Interfaith Centre, run by David Schilling, is still doing very good work in this space. He's actually one of the key investor groups in the US that's been running, as you said, going to annual general meetings and running shareholder proposals. So they're still very, very much in that space and have been doing some work actually recently in relation to the Olympic sponsors, asking about human rights policies and trafficking. And so anyway, that's a side point. But yes, policy coherence in the UN system was also recognised as something that really needs to be improved. And one of the requests that came out of last year's endorsement of the guiding principles was that there be, and again, Holoman episode, but another study done of policy coherence within the UN system to get some of these groups talking to each other much more. I'm happy to say that we are seeing some convergence come through. At the WTO, we didn't spend a huge amount of time on trade issues, to be honest. We spent more time on investment issues, but we did see Pascal Lamy start to talk more about human rights and a little bit more about what the WTO could do in terms of how some of the exemptions work and labelling and that type of thing, so to kind of increase the responsible behaviour by companies. But it's definitely something that I think needs to be worked on further. But there is an interesting paper that I can refer you to afterwards around trade and business and human rights that we can talk about.
Thank you very much indeed, Vanessa. It's been fascinating to listen to you. I'd like to mention that on the 15th of June this year, we had a very interesting symposium on human rights education in Victoria. And one of the startling insights that came out was from a very senior bureaucrat from Canberra who works on human rights issues, who's worrying about the fact that racism in Australia is real and it's apparently increasing, and that formal education and training doesn't deal with it. So I was just wondering, in your work, whether you found any insights into how attitudinal changes, behaviour changes, can be encouraged on sensitive issues like this.
Yeah, and it's very interesting at a company level, because I was just speaking with Sheena before about, you know, if you have somebody that's worked their entire life at a mine in Western Australia and then they end up in Africa or Asia or Latin America in a very, very different environment, and do all sorts of things that get them into trouble, not necessarily, I mean there are cowboys, but not necessarily in a way that they even realise, you know, by perhaps using certain offensive terms or perhaps, you know, not being very respectful of a cultural heritage site or things like that. How do you actually, you know, and these people are, you know, geologists or engineers or that how do you get some of that cultural change to occur? So I think that what I've seen with the companies that I'm working with is that it really requires, I guess, a lot of very, very practical kind of exercises where you're really trying to show them what the impacts of their actions might be. Often through case studies and hypotheticals rather than probably calling them out on particular actions. But actually having those conversations, having the difficult conversations about dilemma situations and creating quite a safe space for them to do that. So acknowledging that things will go wrong and there might be dilemma situations. Something like child labour, which one would hope could be looked at in quite a black and white way, but if you're if you're dealing in an area where there is child labour, it's not hazardous. The children are working after school, and if they weren't doing that, then they the family might lose their source of income. I'm not saying any of these things are right, but it's just having those discussions, at least having those conversations. What I would say is, for a very, very large company, those discussions have to happen at all levels. Nothing's going to work if it only happens at the site level and no one at corporate headquarters is paying attention. So it does need, those people at the top to also have those conversations and for it to drill down. I'm not sure if that answers your question, but I think it's an ongoing process. And it's also something that I think for a lot of these company representatives, it doesn't come easily. What do human rights even mean for them? So even just understanding what are human rights, which ones are most applicable to the company.
Bruce Grant. You haven't mentioned trade unions. Is that deliberate, or are they not part of the conversation?
No, they were part of the conversation. So in amongst civil society discussions, we did have quite a few trade union representatives participate in our meetings. We probably didn't get into labour rights discussions as much as we could have, because often the International Labour Organisation kind of handles that part. So we did talk about it, and we did have trade unions as part of the discussion, and particularly when we spoke about grievance mechanisms. So when we were looking at some of the available grievance mechanisms and the importance of a company, if they have set up their own grievance mechanism, not only not restricting access to the courts, but also not restricting access for the respect of trade union rights and whatnot. So it did come up, but the ILO probably handled that to a greater extent.
Yes?
I'm a student, and I was just wondering if policies are moving towards a more legal approach where companies are punished in courts for their crimes.
It's starting to pop up more and more. So we're starting to see national courts look at this. Obviously there's a situation where a national court may actually be looking at what a company's doing in its own jurisdiction. So some of the laws that we're seeing around non-discrimination, privacy, workplace safety, that might be very, very relevant in terms of what happens within the country's jurisdiction. And then, as I mentioned before, some of these laws that are being used to actually prosecute or civil remedies against companies for what they're doing overseas. So it's starting to increase, but there are not that many countries around the world that have a provision like Australia's criminal code that actually makes it possible to prosecute a company.
Any more? John?
John Alexi, I'm a law student. I'm just wondering what you think is the end process of, first of all, Professor Ruggie's reporting period, now the working group.
Yeah.
Is it heading towards eventually something like the draft norms or something else?
Question, and John kind of referred to it as the end of the beginning. I mean, this was really just the very, very first step. And I think the question as well about trade unions before, it's about bringing all of these different groups into this and starting to have a conversation. I'm not sure it's moving towards, I don't think it's moving towards the draft norms. It might move one day towards something like, and this is just purely conjecture, but something like the UN Convention Against Corruption, which places obligations on governments to bring in laws relating to corporate behaviour. If that happened, I could probably, given what I've seen from the last couple of years, probably see that happening not in relation to all human rights abuses, but probably in relation to those worst types of abuses, so in relation to international crimes. The International Criminal Court at the moment doesn't have jurisdiction, to my knowledge, over legal persons. So I could see something like that happening. I can see much more development in the domestic space, which is where the question before went to, more countries bring in domestic legislation, whether it's criminal or civil or related to corporate and securities regulation in this space. So we'll see. And I think one of the places that it has to go to, otherwise it won't kind of reach that tipping point, is to reach more companies, more civil society actors, more investors around the world in emerging markets, not just some of the leading companies that we've been dealing with.
One last question. Yes.
I was just wondering if you feel that these, I guess, steps towards human rights and business being combined are going to have a more positive impact on the environmental standards that businesses uphold internationally, just in terms of environmental impact and that relation to human rights as well.
Hopefully a more well-rounded approach. So some of the companies that we speak to, someone might see an environmental impact happening, such as access to water being affected, access to sanitation perhaps through disposal practices, pollution of water, but won't realise that by that water source being polluted, a community has lost its livelihood because it can no longer use the water to access its, to fish or to access, places that the community was heading to. So things like that, where it can actually mean that environmental issues are looked at in a more holistic way, which we hope will soon happen.